So I guess it's time to review the San Diego TPO. We've had lots of questions at the association regarding exemptions, and I'm sure you've gotten a lot as well from owners that you work with. So kind of like a reminder is that the transient and tourist hotels are exempt. Short-term rentals, 90 days or less, including 3 months or less extension. Kind of what you have to remember is that the way this was written is that the contracts, when a resident first comes in, you are going to write them for 3 months. So if you need to make sure that it's 3 months and then another fixed term for another 3 months falls until your 12 months deadline. If you're hitting that 12 months, you are no longer exempt. Just kind of a quick reminder of that. The housing restricted by DIN or regulatory restriction, housing subjects to other arrangements that provide subsidies in Section 8. Those are specific homes that are, and the mobile homes are subject to the mobile home residency laws. If they are nonprofit religious facility or residential care home, those and as well as schools to be exempt from this. Obviously, if someone shares a kitchen or a bathroom in a primary residence, those tend to be exempt as well. There are instances that they might not be, depending on the number of rental agreements that you have per that residential property. And then the single family homes that are occupied and where there is no more than 2 bedrooms are rented. That's kind of where I mentioned, depending on the number of rental agreements previously to that. Continuing on, a property containing 2 dwelling structures in which the owner resides in one, then the other one, you are exempt on the other one, as long as that owner is not a REIT or a corporation, or that if the owner is in an LLC, that one person is not a corporation within that LLC. So one of the things that I like to mention before we go into this, the Southern California Rental Housing Association does have all of this disclaimers in the rental agreements. Quite sure if CAR has them updated yet or not, but in the event that you do need them, the association does have them. So a little plug for it, www.socalrha.org.
Is everyone given the notice?
Yes.
Okay.
So if you haven't given the notice, you need to.
It was due a month ago.
Exactly. So you need to serve it now.
And so correct yourself sooner the better.
Yes, because after a while, we believe that attorneys are going to go, judges are not accepting that, I wasn't aware of this law. So if your rental agreement doesn't have it, make sure that you include it. Revise your rental agreements going forward, please. As Mark mentioned, there is a tenant protection guide that you need to provide. This is specifically for properties that are not exempt, even though oftentimes you will hear me say it doesn't hurt to give it to them. If your property is not exempt in the city of San Diego, make sure that you do provide them a copy of that. And again, it is in our website, or you can go look for it in the city of San Diego's website. And I will tell you, thanks to Molly and the association and a couple of the attorneys, she worked really hard to get that whittled down into something that you can actually provide with to your resident. And yes, by the way, you do need to print it out and hand it to them before anyone else. Email doesn't necessarily constitute correct serving when it comes to this. Yes. So buyout agreements, 2 things. They're with the TPO law. You need to notify them if you're going to be doing a buyout agreement. Thing to remember, this notice of buyout agreements, if you have multiple tenants in the property, you need to provide them to everyone. And not only that, when you give them a buyout agreement, if the resident comes back and says, hey, I'm not interested in a buyout agreement, that's it. It kind of closes the negotiation portal, so to speak, for that. Not only that, if you're doing one, consider talking with an attorney. Please talk to an attorney because there's specifics to the buyout. Your buyout cannot equal the amount of rent that you would be either providing them with or waiving. It needs to be a lot more, and you really need that help from a professional to structure it for you. So,
Is that included in the car forms?
No.
so our
There's a new document?
actually, it's kind of, it went into law in last month, as it was mentioned before.
June.
However, June. But however, we've had it on our rental form for quite a few months just to make sure that everyone complies. So we have a letter on our website. We have the acceptance form. And yes, it must be signed, but our rental agreement also includes that on our rental agreement. So
If you'll Google San Diego TPO, you can go to the city website and then the Housing Authority website for the book. The book's what, 15 or 20 pages?
20 pages. So
18 pages. So you're supposed to give a hard copy. If they sign with the lease, I've heard that that's okay if they sign on the form, but just emailing it to them like you would other notice, you have to give them a hard copy.
This is only for the city of San Diego?
That's City of San Diego. Joel, this has their own and they have their own book. Do we need to continue going over San Diego TPL? Balcony inspections. You started them, Eric?
Well, we're doing plans to demolish and rebuild 10 wood cantilever balconies. We got 3 estimates. All the estimates had different scopes and different minimums. And just want to clarify, we're talking about a deck, a landing that you can walk under. If it's something that's enclosed into the building, recessed into the building, and you can't walk under the stairs, then that's not included. But any of these exterior elevated elements, they'll go through and inspect them. Some companies will do 15%. Other companies want to do 100%. Some will only do an exterior inspection. Other ones will drill up and go in with a scope to take a look at the wood, inside that area. If it's something that's made out of wood or something that's attached to wood, you need to have it inspected. For the 4 to 6 unit properties is around $3,700.
$3,700 for the 4 to 6
We
units.
negotiated down to that. I think initially it was around 4,000 something, because some of the companies have a minimum of $7,000-8,000 just for them to go out and take a look.
So these are on 3+ units, wood structure or attached wood. So most of our concrete second, floor landing is attached to wood somehow. That 2-story apartment building is very likely not steel. It's all but 100% certainty that it's wood. So you have to have your first inspection by January 1, 2025, and every 6 years after that for any elevated thing. And I think it's a 5-foot height limit. There's some height limit set to it, but if you have a second story, you've got to do it. You have to keep the records for 2 inspection cycles. So what is that, 12 years? Eric mentioned larger complexes, maybe they would do a 15% study, but it depends on the architect, engineer, contractor, the service provider. Immediate hazards get reported to the city or county building department. And the owner's got to start making repairs immediately on those immediate hazard repairs. And so really you have 15 to 120 days to take corrective action. You have to give the report to tenants if they ask. Every 6 years, you got to do it. So we've started doing, I think we've now inspected all of our elevated structures just so that we could get ahead of the onslaught that is bound to come over this next year, trying to get all the buildings inspected and stay compliant with this law, I think is going to be a challenge. So we ended up calling 3 or 4. Some didn't call back. Yeah, and the company who does the inspection cannot do the repairs. So condos are separate because they're not free. I think HOA has to inspect condos. Yeah.
Are exempt homes, are they exempt or they still apply?
3+ units.
3+ units.
also, if you call the apartment association, we do have a list typically of some inspection companies and repair companies, you're more than welcome to just give us a call and get a referral.
And that's Southern California Rental Housing Association. Yeah. A great source of information. And it's been neat that we've been able to collaborate with PSAR and Southern California Rental Housing Association. We don't always align politically, but most often we do. And we've accomplished a lot of good work influencing some of these things that if you think they're ugly now, you should have seen what the first draft was. Anyone want to talk about EPA?
I just got licensed for that.
How'd you get licensed?
You go online and you pay the $300 or $350 and promise that you'll never use a non-certified contractor for doing repairs where they need to have the lead certification. It's required for all property managers to have it. So if you haven't gone onto the website, EPA.gov, do it. But you do have to get that every 5 years. Make sure that that you've got that, and that all of your contractors that you're using have the same certification as well. And hopefully most of the reputable ones would. But again, any repairs prior to 1978, that disturbs any paint. It's got to be more than 6 square feet outside. Window replacement's always covered. So yeah,
6 square feet inside, 20 outside. Windows always. If you replace a window, you have to comply. And there's this Renovate Right pamphlet. So that Renovate Right, you're supposed to give to your tenant before work starts. And penalties, don't worry, range from not more than $50,000 for each day of violation, and not more than a year in jail. EPA is federal. And then California passed its own law that attached to the federal requirement. There used to be an acceptable level of lead paint, and now any detectable lead paint is a no-no. If the violation results in serious injury or death, it's only $250,000 or imprisonment of not more than 15 years. Organizations, corporations, fines $1 million for each violation. So it's real. There were pages and pages and pages of examples of recent fines, and 2 Chicks and a Hammer settled the violation with this RP rule. They were on TV. They popped them because of the episode. They saw they were not in compliance with the EPA rules, and so they paid civil penalties of $40,000. Now I guess the TV show says, "Hey, this is how to comply with EPA." They made that part of their settlement, and most of the shows on TV been in trouble. A property management firm settled an alleged lead renovation and asbestos violation, and it was failure to be RRP firm certified, failure to ensure a certified renovator. They paid $25,000 pre-78,
pre-1978.
And now if you disturb even on your own stuff, if you disturb enough drywall, you have to have it tested.
Yes, especially your contractors are still required. And another thing to remember is if you have like a condos or apartments and you're there and you're not licensed and your workers are doing that, someone has to have that certification while the work is going on.
Yeah, so
They have to be on site.
on their website, it says any individual or entity. So I think that you for sure have to comply with the EPA rules. Property manager was sentenced for failure to properly notify tenants about lead hazards. So make sure you give them the lead booklet and then that Renovate Right.
And just as a reminder, that lead booklet, you have to give it to them once a year. Yes. So just kind of remember, not the Renovate Right, that's only for renovations, but the lead pamphlet every year.
Within 78 or older.
Correct. On this. That doesn't have to do with repairs. That's just kind of a reminder that, hey, we've already let you know that there may be lead in the property. Here's a copy of the book.
And this manager in criminal enforcement action, June 8th, 22, Paul Hill, was sentenced to serve 1 year probation and pay $15,000 in New York for non-compliance of the lead disclosure rule. So they don't mess around.
You can email it. Just remember that to make sure that you have a copy that they did receive it, acknowledgement.
But we renew leases, even though we go month to month. We review leases every year and include all the disclosures, 98 pages of nonsense. You want to talk about an owner selling now what?
Sure. So we do come across situations, especially in the market right now, with low inventory. A lot of owners, and with all the laws getting passed, a lot of owners are considering cashing out, moving their money to another state, another country, offshore, other investment instruments. So when an owner approaches us and says, hey, I'm going to sell a property, I'm not using you as the selling agent, always good protocol to be very cooperative with that other agent, even if if there had been prior verbal agreements or things like that. My best recommendation is always to, be the bigger person and make sure that you're compliant with everything. And that includes, when the seller's filling out disclosures, the seller has to disclose all of the repairs and everything. Make sure that they have that they've been given those list of repairs. Make sure that they have all that stuff to disclose. That way they're not coming back to you saying, hey, how come you didn't tell me about the faucet replacement or whatever the case might be. So make sure that your records are complete and you're passing those along to that other agent and or the seller.
So you're suggesting run a maintenance report?
If your software allows for a maintenance report, I think that's a great idea.
Yeah.
Worst case, if you have a general ledger that shows payments out, audit that. And if you've got a charge to a handyman, pull up the receipt and include all of that stuff. So I would highly recommend that. If it's been 20 years that you've been managing the property, there might be a lot of stuff on there.
How do you handle communication between tenant and realtor who doesn't work for your firm? What's the best way to deal with that?
I don't have a lot of experience. My general recommendation to owners is when they sell is get the tenant out first. That may not be as big of a deal with multi-unit properties since they're generally sold with tenants in place. Have the listing agent reach out to the tenants and I'll coordinate letting everybody know who is who and what to expect. But I kind of leave it up to the listing agent to coordinate those showings and walkthroughs and all of that. But if they're insistent that you be there, maybe that's part of your management duties. I don't want to be the one getting in the middle of setting things up and being the one that's causing delays in setting up inspections. So typically, I think it's best case for listing agent to handle all of those things. I'll do the introduction from a management standpoint. I'll do the introduction with the tenant just so that the tenant knows that, hey, this other agent's legitimate. And so I've had some that have been really difficult in terms of allowing access or photos and then I've had some other agents that will incentivize, they'll do compensation for each showing. I usually do the initial introduction and then try and stay out of it.
What's worked for us is let's incentivize the tenant with some type of free rent, discounted rent for cooperation. And if they're not being cooperative, I know our lease says we can demand a showing with 24-hour notice. That's not something I'd be willing to force the issue on personally. And I don't know how you functionally would do that, but maybe by cooperation and, hey, tenant, it's not working. You're not being cooperative enough. We're going to rescind this offer. And now we're just going to go through whatever the notice requirement is, see if you can get them out before you try and show the property if they're not being cooperative. Smart. So you changed the lock to have 2 keys. It's something I hadn't thought of. That's a great idea. Eric wanted to talk about everybody's favorite topic, evictions.
We haven't been filing a lot of evictions. Fortunately, people have been vacating on their own. They're not able to pay the rent. We did have some success stories. Someone that was going to vacate and the city of Chula Vista is actually doing a one-time payment for their back rent. So that's another option. If you've got someone that is in a difficult spot, reach out to the county, reach out to the city of Chula Vista has a homeless and housing department. We're doing our best to keep people housed. But we did have someone in El Cajon that was subletting. We didn't know the people they were subletting to. We filed they weren't paying rent. The person on the lease was not paying the rent. And so we filed for non-payment and went to default. The sheriff posted their notice on the door, and we've had good luck. Usually within the week of the notice being posted by the sheriff, we get a call for the lockout date. But I just wanted to let you know that things usually move pretty smoothly. But if there is any delay there, delays like that can be costly, and reach out to your local representative to break things loose.
And so it sounds like the supervisor kissed the sheriff to make the lockout happen.
Right. And what I learned through that is that the county supervisors, they can't provide directives to the county staff. They have to work through the county administration. So the supervisor's representative reached out to someone, and then that person contacted the sheriff's department.
So we have one we're in the lead on. And so I think we'll call the supervisor's office and see if that'll help us. That's a great idea.
As for keys, are there any restrictions as an owner wants to do that with the tenant as his will?
Yeah, you can do cash for keys, but remember, if you're in city of San Diego, they have restriction on buyout agreement and Chula Vista also. So make sure you comply with those because those fines are punitive. So I don't know how many agents are in the room. Frequently at these, I'm an agent working I do sales through Coldwell Banker West. We're not allowed to do property management at Coldwell Banker West. I see, and I don't know any agent necessarily at Coldwell Banker West, but I'll use that as the example because that's where I do my sales through. Well, I'm just going to help my owner, my client, and I'll collect rent when they're out of town. I'm going to help them with a lease just to be nice. You're not covered. You're in violation of your employment contract with your broker, very likely. You've put yourself at great risk. So I know we're trying to help our client. Oh, I'm going to do this for them. They're out of town. I'm just going to collect some rent. You're really performing management services unlicensed. And you could get yourself and potentially your company in big trouble.
Mark, can I speak to that real quick?
Sure.
So I was just reviewing a lease that had been contacted by an owner. A friend put together a lease for them. And the first thing I think of, okay, they got it at Office Depot for $50 and it doesn't have anything. Luckily, they used the car form, so I know who it was. But then I always look to see, did they get the RCJC, the rent cap just cause? And they did, but they didn't check the box for the exemption. So there's a lot of agents that are out there looking to, help their clients and everything, but they really could have put their client at a lot of risk by doing that and not including everything, not to mention they didn't have the exemption from the ordinance of the city that it was in. And so when I had the conversation with the owner, I could say, hey, the lease is there, but there are things that are missing in it that might have these ramifications if you need to do this. So yes, we can take over management, but we're going to be coloring in different lines than we would have been if you'd done the right thing in the first place. And a lot of owners don't know that. So if you are working with an agent on the other side and they're drafting the lease or they're representing, just make sure the paperwork's right before they sign, just for everybody's protection. It makes things so much easier for everybody.
And honestly, as an agent who isn't allowed to perform property management services with your independent contractor agreement, you're really putting yourself at a lot of unnecessary risk for what reward? ESA letters, emotional support animal letters. How do we handle those?
Very carefully, right? When I have conversations with owners up front, when we're talking about renting their property, I always set the expectation with them, even if we have a pet policy in place, and we always do have a pet policy in place, regardless of what that is, if the tenant has a legitimate emotional support animal, and I always put legitimate in quotes, we still may have to allow that animal in the property. And I think a few, maybe 5, 6 years ago, we saw a lot more fraud in regards to that. We still see some now, but it's not as bad as it used to be. My understanding, and correct me if I'm wrong, they have to have a letter or prescription or note from a physician, a therapist, or someone who's competent to be able to make such a recommendation from the state of California. And in order for that to happen, that person has to be seeing the patient for at least 30 days before they can make that recommendation. Make sure you have those letters from the physician. Some people I know will follow up with the issuing agency to make sure that they actually issued that letter. I think that's probably a good practice if you're doing that with everybody. And especially if it looks funky or wonky, you've seen some weird things out there. You can ask for the letter, you can't ask for the reason.
One thing, during the operational advice for the association and during the past 2 weeks, I have gotten a few calls and they were from an emotional support. The person that was giving them was a student under a licensed professional in the state of California. So if you were to see one of those, stop, don't deny it right away. Check with the licensed professional, because that is allowed in certain instances under the state of California. So we had about 3 or 4 of those calls come in, different people. One person did verify, they go, yes, they are doing their practices with that physician, and the physician signed it, and so did the other person under the license of that physician. So just keep that in mind.
So in part, we changed our pet policy because how many people have walked into a place, oh, when'd you get a dog? When'd you get a cat? When'd you get a lizard? Whatever, right? So to me, that ended up being a battle. We have there's surveys out there that 70% of tenants in San Diego County say they either have a pet or would like to be able to get one. And so when we're onboarding new owners, we convince them allow pets. And ESA letter, who cares? Let them bring the animal in. That's really how we've decided to handle this. I don't want to go seeing if this is a real letter, because the 3 letters that I've seen were all for pit bulls, and I didn't believe one of them. But we took no action because who wants to be, fair housing claim v. Encore Realty, even if Encore Realty wins. And my friend did win their fair housing claim. It cost them $50,000 to win. So for me, it's not worth the risk of even fighting the les. But those that do, you got to be very careful on how you do with that. Oh, so Myra brings up a good point. Who charges a pet deposit and then a security deposit? No one. Good. Because what she said is if you do a pet deposit at $300 and the dog does $800 worth of damage, you've limited your security deposit taking to the $300 pet deposit. And you can't get the security deposit for the damage the dog caused.
Could you argue that one of the tenants chewed up the baseboards?
Maybe. So the Los Angeles AIDS Foundation and Michael Weinstein or something, they got rent control back on the ballot again for November 2024. This actually hurts renters in a bad way, and it hurts housing providers. It hurts them both. I do think we're going to be seeing changes to laws that will limit rent to rent increase on the non-exempt AB 1482 properties to 5% or CPI, whichever's lower.
Same topic of rent. I think one of the biggest issues with this rent control initiative is vacancy decontrol.
Yes.
If you've got a rent cap, 5% plus CPI, if this passes and you have a local jurisdiction where you can't have vacancy decontrol and you've got that low rent, someone passes away or moves out for some reason, then you're stuck at that rent.
For domestic violence, just kind of a reminder that there are forms out there. They need to prove that there was some sort of domestic violence either against them, a family member. There's a law about the 14 days that they can give you a notice and be out within 14 days. And basically, if you're in a fixed term lease, that basically nulls and voids that fixed term lease right then and there once they let you know that a tenant has the right to terminate their tenancy because there was something having to do with domestic violence. The other thing to remember in regards to that is that if it is happening, someone can write a letter on their behalf. It can be a nurse, a doctor, or it can be a family member to let you know. If it is an official, like a policeman, they give you copies of that police report or copies signed by a doctor or something that says that there was violence happening. Obviously, that's really easy to prove. If it's physical violence, just remember when it's mental violence, it is very different, but it does happen. And again, that 14-day law applies.
No fault, just cause.
No fault, just cause. For Durazo, they thought to overhaul AB 1482 by lowering the rent cap. And essentially for single family homes. So kind of to keep in mind that this is since day one of the occupancy and residency. And this also covers that 12 months of continuous residential on a person's primary residence. So keep that in mind, that it will require the name of the people that are moving in. So this is when you're saying that a family member is going to move into the property, you will need to provide them that information. Who it is, that person moves in within 90 days, and they need to stay there for at least 12 consecutive months. So careful when you're going to be doing those evictions or say, I'm having a family member move in. Relationship, name, address, move in within 90 days and stays a year. So keep that in mind. And if you're asking them to move out because they're going to do a substantial remodel, better make sure that you have a copy of all of the permits, the lengths of the work that's going to be done, and everything, because that will be required.
So it's very similar to the tenant protection ordinances. And there's new law enforcement mechanisms in AB 1482. This starts April 1, 2024.
So
Yeah.
make sure that that's given saying, I'm going to be moving into my property, and they move in within 90 days. So if they're
About the 12 continuous.
They have to live there that
Yeah.
long.
every time we talk to owners, they're saying, I'm going to move in, quote unquote. And then 2 months later, I redact it, I'm re-renting it. We've always said, you know what, you want to wait at least 6 months, stay in your property 6 months to a year, just to make sure that that's viable and someone doesn't take you to court later on. And lo and behold, now it became law.
Who loves security deposits going to 1 month only?
And that law will take effect on July 1st, 2024. The security deposit to 1 month, regardless of whether the unit is furnished. Now that law where you could get 3 months worth of rent if the unit was furnished, that goes out the door and it's all 1 month. There are limited exceptions to remember. Basically, if the landlord is a natural person, they have no more than 2 residential rental properties that collectively include no more than 4 dwelling units offered. So what does this technically mean is if you have the owner, one property has 2 units, and then the other property that they own, even though it's in another city in the county, that's still, if that property has 2 units, that's a total of 4 units. That's it. The interesting part is, how are they going to verify that?
And what are you going to do to make sure? We have an owner who has a house in Imperial Beach we just started working with. And I was talking with them because of this. Hey, how many units do you guys own? Oh, well, I own 6 in San Jose and I own 1 here in San Diego. Well, they now have to comply with the 1 month only security deposit. So now it got me thinking, well, man, now we have to get verification from owners of, I declare that I only own X number of units. that I rent out? What if they acquire another one after you got this certification? So we have to always be, or do we keep our security or our written rental criteria compliant with this law so we don't have to keep track of every individual owner? And I think that's the way I'm going. But we had conditional approval where, oh, your FICO score is a little low, whatever, you can pay 2 months security deposit. Well, now I can't if the owner has, owns 3 separate houses or more than 4 units. I didn't read that they have to be California-based rentals. Do you know if it's specified?
No, it's not specified. And that is one of the other issues. The law is very vague on how they're going to make sure that owners, and not only that, all of those lawsuits that could potentially enact, because I think you have more units than what you're declaring, how many of those are going to happen?
And then I own it in LLC. Well, the LLC only owns the one. I own 12 LLCs. So I mean, there's lots of can of worm. If you're doing it to try and skirt this law, I wouldn't like to be on that side of the lawsuit. I'd take 1 month security deposit and increase my rental criteria, which is what I think I'm going to do. But I just started working with the attorneys yesterday in trying to get this figured out before the July 1st deadline next year. So we have lots of time to work on it. But
And if you're working with owners, start asking them, start surveying them. How many units do you own? Where do you own them? Make sure that you are aware if they have other rental housing.
so then SB 712 is micro mobility device law. You can't say they can't have them. This is like a scooter, electric bike, anything like that that transports individuals or one adult accompanied by 3 minors. 3 months ago, the corner house on Philly and Sprinter, the garage caught fire. What caused the fire? A lithium-ion battery remote control car. What I sit on the Bonita Sunnyside Fire Board. I was reading this, getting prepared. Hey, fire chief, what are you guys seeing? So I called our fire chief, and the county board of chiefs is talking about how do we handle this. The city of San Diego has a great resource on charging lithium-ion batteries. They are starting to cause more and more fires. This is going to be an issue. Now they're saying, hey, you have to allow them. The fire chief in the city of San Diego wants to outlaw putting a scooter on an elevator. So you live downtown, you have a scooter that you ride to work or school or whatever, and there was a fire, those batteries turn into poisonous toxic gas almost immediately, and they burn very, very hot. And there was a fire in an elevator, and the people are trapped. So this is going to be an issue. It's in its infancy, but you do have to allow for that. There's different resources if you put lithium-ion battery safe charge, and they give tips on how to safely charge the lithium-ion battery. Our fire chief in Bonita says you shouldn't charge overnight. You shouldn't walk away from them. You should kind of watch. And so this law goes into effect January 1.
So now we have SB 267, which limits basically how you can run a person's background check credit history. So where this comes in is specifically if they're receiving some sort of aid, like Section 8, a person can come to you and now basically saying, look, I don't want you to run my credit check, and I want to prove that I can actually afford this place in a different way. So SB 267 now allows for that, and it will go into effect on January 1st, 2024. Keep that in mind. It basically lets the person provide a different type of proof to you about how they can afford that housing. And here is one thing to keep in mind about the law is that you can request that additional information, but it doesn't tell you how much is considered reasonable time for them to hand that to you. Pay stubs, typically when you have someone, but you cannot verify whether or not that person's meeting their other financial obligations. You can't, what you're verifying is that they do make enough to pay their portion of that rent. Essentially, that's what it is. Obviously, there are things, kind of what we were discussing earlier this morning is, yes, potentially you could say, look, you're taking too long to provide this information. But again, what is too long? It's not defined.
Yeah, but what is reasonable gets to be what the fight will be over and what the lawsuit will be on. And a week probably isn't enough, would be my opinion. Yeah, but if you require 2 times rent, right? You can, but the voucher, remember, counts towards that.
Correct.
And
I'm talking just about the documents.
No, so here's the thing, not only that, if their portion is, this is just an example, is their portion is $300, they only need to make $600. But it has to be verifiable information. Can you verify based on those documents whether or not they could do bank statement work? If you see that $600 coming in every month, in this example, that would work.
the law is poorly defined in this area.
So do we have to give preferential treatment to somebody that is a protected class?
So this is specifically for people that are, for example, under Section 8, that are getting into a second class.
Yes. Yeah, any kind of voucher program, they can give you, whatever, verifiable income.
That one's be
Yeah, well, we'll see what happens.